How you guys doing today? It's Anthony Ganji. Welcome to another episode of Chair Talk. Guys, we are going to revisit the Jesse Mack Butler case out of Oklahoma, but it's really an effort to compare his case to Seth Robert Swaim. And they're both out of Payne County, Oklahoma. And basically, me and Russ, he's my guest today, we are going to discuss, are they being too lenient, especially with these type of offenses. I'm going to also show a video from News Nation that's around 9 minutes, and then we're going to go into our bit of a deep dive into this. And guys, I have done a video on Jesse Mack Butler. It was about an hour and change. It's in full detail of what he did. If you want the full details of that, I would definitely recommend you check out the older video. But in the meantime, we're going to go ahead and continue the discussion because people have been reacting to that last video. And now News Nation is starting to dive in deep about other cases in Payne County that many are thinking are a bit too lenient because sex offenses, those offenses are usually the type that reoccur. They're offenses out of compulsion, in which most people will tell you those offenses are very hard to rehabilitate because, again, they are crimes of compulsion. And guys, if you like the content, don't forget, I have buy me a coffee. I usually put it in the description of the video, or you can find it on my title page in the description of the channel. Okay, let me get Russ. What up, Russ?
Hey there, Anthony. How's it going?
Good. This is going to be a good dialogue. You know, me and Russ are figuring it out as we go. But Russ, do you mind introducing yourself to our audience?
Sure. My name is Russ Hamilton. I am a former and retired sergeant from California Department of Corrections and Rehabilitation. I began my career at San Quentin State Prison back in 1989. I'm also a former juvenile correctional officer. I'm also the founder of Keepers of Chaos with a K on Facebook that's designed to mentor and deliver all sorts of content, history, training, and so forth to correctional professionals, be they the badged ones or not the badged ones. In addition to that, I am also the author of a book called Killing Complacency, Tactical Awareness for Correctional Professionals. And I currently work for a company that does reentry and rehabilitation work at a local county probation department and a local county jail where I'm the case manager.
Yes. And guys, just to make it easier, I just posted on my Tier Talk post board, whatever it is. You can get it through when you look at my channel on YouTube, the other video we did on the Jesse Mack Butler case. Now, again, we covered it in the last video in details, but we're going to get into some details here. But that really broke it down in some serious details. But right now, let's go to this News Nation video to kind of give us a breakdown of, you know, what the context of our discussion is going to be. And then we're going to go back and basically discuss the topic. All right, so let me bring this in. I'm going to mute us, Russ.
If you have followed our coverage of the Oklahoma teenager who was convicted of brutally raping and strangling two of his ex-girlfriends, almost killing one of them, only to have his 78-year prison sentence magically disappear, I hope you're sitting down, and I hope you've had a sip. Because we begin tonight with a sickening update to that gut-wrenching perversion of justice. It's another story, but from the same county, same court, and even the same judge, suggesting that the sweetheart deal given to that kid, Jesse Mack Butler, I say kid, he's an adult. He's going to turn 19 soon, right? Committed his crimes at 17, but the whole, adult thing he was raised to just went away, got knocked back down to youthful offender. Starting to look like maybe that wasn't a fluke, right? Butler's deal centered on being reclassified from adult to, quote, youthful offender. And for whatever reason, the prosecutor and the judge both signed off on that deal, which means, just like that, the now 18-year-old swapped 7 decades of hard time for community service instead, with a little bit of counseling and a curfew and no social media. And when he turns 19 in just a few months, his record will be expunged. Don't go searching for him if you're trying to date him or if you're going to hire him. It won't show up. But none of that would have worked for Seth Swaim, who was just a little too old at age 24 to qualify for such a deal after being caught sexting a 13-year-old, a little girl, back in 2018. At the time, Swaim was a teacher in Cushing, Oklahoma. Obviously, he isn't anymore. Police say he stalked a 13-year-old student on Snapchat and asked her to send him sexually explicit photos and then meet him in private. There's even, descriptions of him trying to crawl through her bedroom window. And a year later, he pleaded guilty and was given a 10-year prison sentence. Makes perfect sense to me. But wait for it and have another sip. That sentence was suspended. Reports vary on how much time he actually spent in the lockup, but it wasn't a whole lot more than a year, tops. So Seth Swaim got out of jail. And fast forward 5 years to July 2024, guess who was arrested again? Yup, take a third sip. This time for allegedly raping a 16-year-old girl at a gas station in his truck. For reasons not entirely clear, that charge against him was dropped. And then last October, Swaim was instead charged with 10 counts of engaging in sexual communication with a minor by use of technology. In other words, sexting, which I think we can all agree is a far cry from raping someone at a gas station. Still to sexting, well, that violated the ex-teacher's probation from the earlier sweetheart deal he got, and I'd have my eyes shut too. So in June of this year, he was sentenced to 8 years in prison, not suspended. But the newer cases and the newer victims would never have happened had this guy served out his first sentence. The one where he was given 10 but served 1. I'm joined now by someone who knows a lot more about these cases than I do or anyone else. Justin Shepard is a digital journalist who posts under the handle Just in the Nick of Crime. He's been on top of this story and the others from the jump. Justin, this is the kind of thing where I think the folks in Payne County should be out in the street with pitchforks. Are they? And if not, why not?
Well, they're getting there. Apparently on November 5th, there's going to be a protest starting at 10 a.m. at the courthouse in Payne County because the citizens are very frustrated with it. They're very appreciative to have the spotlight on there because, a lot of them, we're talking about 2 cases, but there are so many more. People are messaging me, telling me about their own stories and just the fact that this seems to be a very common practice in Payne County, and they're furious and they're tired of it.
So the judge in the case is it Judge Susan Worthington? Do I have that right from the last time you were on with me about the story? Okay.
Correct.
How did she sign off on it? Judges are judges. They're supposed to be Lady Justice, right? They see nothing, they hear nothing, they go on the facts, and these facts are filthy in both cases. How did this happen?
That's a great question. And I think a lot of people are trying to figure out why this happened or how, because like you said, he was sentenced to 10 years. And you're right, there are varying reports. I've heard anywhere from 8 months to about a year and 4 months. Either way, not long enough. And then he gets out. And just a quick thing, so you're aware, apparently he didn't go back to jail. The violation of his probation was not the fact that he was sexting a 16-year-old girl, not the fact that she was raped. It was the fact that he got a DUI. He apparently violated this protective order 10 or 11 times. The Judge Worthington, kept giving him a fine of $500 to $1,000. Seth's mom kept paying it. He kept walking free and kept violating one right after another, which in my opinion is just a total disregard of the justice system and the court's orders.
So let me get this straight. He is sexting a 13-year-old, asking for dirty pictures. He's climbing through her bedroom window. He gets 10 years. He serves 1. He gets out. He's now maybe raping a 16-year-old in his truck at a truck stop, but that charge gets dropped. Then he's sexting with a minor. I don't know if it's the same as the 16-year-old or a whole other victim. And 10 times he violates his orders under probation, and they just slap him on the wrist. His mommy pays a fine, and he's free to roam about the cabin till he drinks and drives. That's what got him back behind bars, not the sexting with kids?
Yeah, correct. The reason he's back behind bars right now, and he's in county, he's been in county since, my understanding, since like June 11th. They've not transferred him back to a prison. Nobody really knows why. But yes, when put him back behind bars, what the official probation violation wasn't the acts committed with these underage girls, with these minor girls. It was the fact that he was drinking and driving.
Okay, so is there a trial? Okay, I'm trying to figure out what reason he'd be stuck in the county jail instead of going to prison where he belongs. And it's been 4 months. You said June. We're now at the end of October. So is there a trial coming for what he did to the underage girl 10 different times by sexting with her?
So there is litigation that's proceeding based on all of that. My understanding is in November, there is a status hearing, and that's kind of the next step. But that's kind of where it's at. There's not an official trial. Like I said, the next step is just a status hearing. And that's, again, since all of this started, since his arrest again in June, where he had probation violation to now November, it's just the wheels of justice here are turning very slowly on this, because a status hearing, that's going to be quick in and out, and then they'll set another date.
Sounds like they got molasses in the spokes, for God's sake. Can I ask you about the rape charges? I said something's rotten in Denmark, and
Yeah.
I feel like that might be the one that's the most rotten for Swaim, certainly not for Jesse Mack Butler. But is it possible that the rape charges could be reignited now that maybe the pitchforks will come out and people are eyes on, and now it's possible to bring them back unless they were, unless they were dismissed with prejudice? What do you know?
So I don't have the full details on that. I would think that they possibly could, now that there is a pretty large spotlight on Payne County, Oklahoma, on this particular judge. With, I know you had on Representative J.J. Humphrey the other night, and I spoke to him too the other day. He's looking to put together a grand jury on all of this. So I'm hoping that maybe that will cause some of this stuff to go the way it should and bring that charge back. Because at the end of the day, no matter what's going on, a 30-something-year-old man has no business being anywhere near a 16-year-old girl that way. And the other thing that I'll add to that as well is, what I understand is that where he met that 16-year-old girl was at work, and the place of employment apparently, allegedly, knew that he was a sex offender, that he wasn't supposed to be near children, yet hired him at a place that teenagers worked.
Well, there's a civil suit, and it shocks me. 10 violations of a protection notice. And that's just not enough for a guy who's already been sent away for 10 years and got a pretty little favor getting out in one. It tells you that he hasn't learned his lesson and he continues to violate, and it's not going to change. Justin, let's stay close on this on speed dial. I mean, just like I said, that representative you told me about just a moment ago, he said it's the tip of the iceberg, and he's actually coming up right after you. So thank you for this, Justin. I'll talk to you soon.
Absolutely. Talk to you. Thanks for having me.
All right, Russ. So there's a lot here. Let me just do this little beginning, and then I have questions in each section. But just a little bit about Judge Worthington. Just background facts. Susan C. Worthington is registered as a special district judge in Oklahoma, serving in District 9, which covers Payne and Logan counties. She was appointed to the bench in 2015 for Logan County as a special judge. Her professional legal profile lists her education as a bachelor's from Oklahoma State University in 1974, a BM in 1976 from OSU, an MM from Indiana University in 1978, and a JD from University of Oklahoma in 84. I don't have a official biography for her that has her full judicial history beyond what's in the database. But Judge Worthington is a legitimate judicial actor with decades in law and service as a special district judge in Oklahoma. However, given her involvement in high-profile cases, including youthful offender dispositions and violent sexual assault matters, the lack of detailed public transparency about her decision-making in those cases has become a point of public critique and concern in Payne County. She is the center of this. All right, so we start with the very beginning, Russ, because there's a lot there. Where am I? So this is in Stillwater, Oklahoma, home to Oklahoma State University. Friday night football and a proud small town identity has suddenly found itself at the center of statewide discussion about justice, accountability, and the limits of leniency. Two names, as we saw, former teacher Seth Robert Swaim and Stillwater teen Jesse Mack Butler, have become shorthand for what many Payne County residents see as a pattern of soft justice in serious sexual and violent offenses. In both cases, the legal outcomes appear disconnected from the severity of the acts described in court documents. Swaim, a teacher once trusted with middle schoolers, was first convicted in 2018 of using social media to groom and exploit a 13-year-old student. 6 years later, while still on probation, he was arrested again, this time on a rape complaint involving another teenage girl. And then we have Butler, a 17-year-old Stillwater student, faced 11 violent felony charges, including rape and strangulation that doctors said nearly killed one victim, yet received a suspended youthful offender sentence that required no prison time if he complied with supervision. He was possibly looking at somewhere between a 78 to 80-year sentence, but now it's been kind of pushed aside as now he's been status changed to a youthful offender. So together, these two stories have turned Payne County into ground zero for a deeper debate. When leniency becomes the norm, who is truly being protected, the offender or the community? So Russ, when a county develops a reputation for leniency in violent or sexual crimes, does that reflect compassion, or does it reveal a systemic blind spot that endangers the very people the justice system is meant to protect?
The thing that I see, everywhere across the nation right now is just an overall leniency. And a lot of it is done, with respect towards, ostensibly some type of rehabilitation. Rehabilitation is difficult in any type of case, but it's much more so with these types of, what I would call violent sexual predators. And so I don't know what's going on there other than to say they're not doing their due diligence. I would dearly love to see, what the sentencing recommendation early on was from the district attorney. It seems like in these cases that they're just, determined to let the predators prey. As it were. And so I think that this is where, we've seen a huge influx across the country of various district attorneys, various, attorneys general and so forth that have run for these offices. And they've been backed by money that's, really, truly, focused on letting criminals get away with things. And so I think that that we've got into this thing, countrywide. It's not just any one state. It's not just any one district. And I think that, people had better start being a little bit more prepared to identify what type of candidate that they want that's handling these type of cases.
Yeah, and Russ, I have to agree with you. I mean, it's funny how we're seeing leniency a lot since we really started diving into the true crime. I mean, Emmanuel Harrow's case is one where what Jake Harrow did his first time around in 2018 and the lenient sentence there. And now look where we're at. Tomorrow he's due for sentencing. I believe there's a push for 31 to life. But I'm thinking the public defender is going to try to lower that down. He's been cooperative, whatever it is. He's going to try to lower it down to maybe 15 years, but we'll see. I mean, it's all guesswork here, but tomorrow he has his chance to kind of be upfront and honest and, what actually happened here. So we'll see if we'll get a little bit of that. But, I just feel for some reason that there is more towards leniency and rehabilitation, because I believe people think that the only way you're successful is if you rehabilitate. And that is not the only way that success should be seen. Success should be seen in preventive measures as well, when noting that this person cannot be rehabilitated. Their crimes are crimes of compulsion, which means that they're going to go out and they're going to do it again. But on top of that, it's only going to escalate. It's only going to get worse. You see it with Emmanuel Harrow. You see it with Keon King in the Kata Scott case, even though we haven't covered that. I've been following it. And that's someone who should have been through the system multiple times. You also see it in the case with the young girl in the subway. You got people that are being too lenient, thinking that's what is expected of them. And then the problem is justice gets sacrificed for the hope on rehabilitation. But the only definitive thing you got, to be honest with you, when it comes to safety and security is actually safety and security. It's the preventive measures that allow for us to hold that person in place because they are a risk. And I think, like Russ said, you put a lot of hope in the fact that people can change. And I would like to believe that, but I've been in the business long enough to know that people have to want to change. I have hope in the effort that the people provide in the workers that I've seen. I have plenty of hope, but they'll be the first ones to tell me, hey, that person can't change. And at this point here, these are the things that are recommended, because I'm no longer focused on this person. I'm more focused on the potential that they can hurt others. So I agree with you, Russ, 100%. It's like, if I could do a more lenient sentence and push on rehabilitation, then I'm considered the success. When at the end, rehabilitation, it's only up to that person. And if you have a compulsion to do what sex offenders do, there is no rehabilitation. There's only delay until they do it again. And some people are even saying, Russ, that this could all be political too. They say that the judge has all these political connections. So I don't know if there's a political push or pressure for more lenient sentencing, which seems to be the case, to be honest with you, nationally. So I got a little bit about Seth Swaim. A lot of us believe, especially what I'm reading now, that his story is rather predictable, that he's a predictable risk that that people have chosen to ignore. So in 2018, Cushing middle school teacher Seth Robert Swaim, we saw his picture in the News Nation video, was arrested after investigators found he had been using Snapchat to send sexual messages to a 13-year-old student. The crime was deliberate and targeted, not impulsive. He knew her age, he knew his authority, and he still crossed the line. There's the premeditation aspect, and then, of course, the cover-up afterwards. Court records show he pleaded guilty to using technology to engage in sexual communication with a minor, a felony under Oklahoma law. He received a 10-year suspended sentence with a short jail term, serving roughly, from what I saw, 1 year and 40 days in Payne County Jail. And that was before being released on probation. Parents in Cushing remember the shock. A trusted teacher, a known face at school events, suddenly accused of preying on a child. Many assumed that kind of betrayal would carry lasting consequences. Instead, Swaim returned to the community under supervision with the assumption that counseling and monitoring would prevent future misconduct. Guys, I want to add something too real quick before I finish this off. Is remember, teachers are positions of trust. So sometimes these predators put themselves in those positions. So the plan isn't just, just about the Snapchat. The plan is to put themselves in a position so they're exposed to our vulnerable children. But 6 years later, that trust collapsed again. In August of 2024, Stillwater police arrested Swaim on a new charge, first-degree rape of a 16-year-old girl. According to the probable cause affidavit, the victim said she repeatedly told him no, tried to push him away, and was terrified when he refused to let her leave his truck. She reported the assault immediately, and police gathered both digital and physical evidence. Then came a twist no one expected. In October of 2024, the rape charge was dismissed. Prosecutors offered no detailed explanation, saying only that evidentiary issues prevented them from moving forward, and there was no refiling that was followed. But investigators weren't done. In November of 2024, Payne County prosecutors filed 10 new felony counts of Swaim engaging in sexual communication with minors, eerily echoing the same conduct from the 2018 case. By June of 2025, after a probation, revocation hearing, Swaim's leniency finally ended. Judge Catherine Thomas ordered him to serve 8 years in prison, not for the new allegation, but for violating the term of his 2018 suspended sentence. And that's related to the prior charge. It took 6 years, a dismissed rape charge, and 10 new counts for the system to enforce the original sentence it had chosen to suspend. So, Russ, if convicted sex offenders reoffends in nearly the same way after early release, who bears responsibility? The individual or the system that underestimated the danger and gave them the chance to do it again?
Well, my real question here, if I was looking into this, would be what that probation department is doing. Here, I know, like with the probation officers that I work with, they have specific officers that are slated to check up on these people, repeatedly. The other day, I was talking to one of them who had just got done doing all of the checks in the county for the upcoming Halloween thing to make sure that these people weren't displaying any Halloween decorations, didn't have their house in an inviting way to invite trick-or-treaters. As a matter of fact, I think that, some of them are ordered, to stay in their house and to not answer the door for trick-or-treaters and things like this. In this case, it seems like it's a failure at multiple levels. We have a failure by the judge, a failure by the DA, and a failure by the probation department. And so I think that, you have to ask yourself and I say probation, it could be parole. It wasn't necessarily clear in that, but, what are they doing with regards to, actually supervising these individuals? And so if they're not adequately supervising them, then why are they out on probation or parole at all? If we're assuming that, hey, they don't have the capability to do these things. So I'm kind of like covering all the bases here, all the things that they could say, oh, we don't have enough manning. Oh, we don't get backing from the judge. Oh, we don't get backing from the DA. It's still their responsibility, and they still have an affirmative duty to act on that. So I think that there's enough blame to go around, but this is typically where we see the blame shifted back and forth so that no one actually can be held accountable.
Yeah, but Rush made a very good point, man. When they start making the changes to these systems, and kind of become more lenient, I don't think people are really looking at the resources for oversight. So, I mean, you're right. I'm not saying it's an excuse, but I will have to say they are overwhelmed with caseloads, and, they have to deal with the policymakers, the lawmakers. So it's like, okay, now we're going to be a little bit more lenient, which means that we put a lot of these people back on the streets, and we're entrusting that they're going to have proper oversight. But in the end, if you look at all these caseloads that our probation and parole people are overseeing, they're overwhelmed. And how do they prioritize, who gets that more needed, more direct oversight? That was a good point, because I think, Russ, right, when they made those changes, you think anybody asked if there was enough to cover the oversight if we're going to keep on releasing them with these lenient sentences?
No, of course, that's it's usually, either focused on money or focused on agenda, and either way, and sometimes the excuse of money is part of the way that they focus on the agenda, so not to get too deep into the weeds, but just look at the amount of influence being wielded over various district attorneys, judges, and so forth across the nation over the past 8 to 10 years, and you can see where all of that money is coming from, flowing through, and going to, and there's just so much of it that's really dedicated towards the abandonment of accountability on purpose. It's not an accident. It's on purpose.
Yeah, and guys like this in the system, I think we in corrections would call them like a predictable risk, which means it's letting them out early isn't about rehabilitation. It's about the fact that we're going to give them a chance to reoffend. I think for these guys, sex offenders, they need, one, to be locked away for safety and security reasons, 100%, because their crime is a crime of compulsion. It really is. Some of them will tell you that they have trouble controlling the urge. So the only tools we may have is, yes, of course, we will try our best to rehabilitate behind the wall, but we also have to make note that these are crimes of compulsion. And at the end, if there's no direct oversight, they eventually stop, suppressing it, and eventually they go all out. So these are truly individuals that, yeah, you can have the hope that the system could rehabilitate them, but you could talk to a lot of people who work with sex offenders, and what they say is they try to help them manage the compulsion. But in the end, when there's no oversight or something is just too enticing, they're going to go for what they go for. They're predators, guys. I mean, that's what they are. They're predators. They attack, the vulnerable. I want to get a little to Jesse Mack Butler. The youthful offender meets violent allegation, because when I was looking at Jesse Mack Butler, that's when all this came into light. So I wanted to bring him back into the picture a little bit too, because it's kind of the same concern. It's the same area. So in February of 2025, 17-year-old Jesse Mack Butler was arrested in Stillwater on 11 felony counts, including first-degree rape, attempted rape, sexual battery, forcible sodomy, and domestic assault and battery by strangulation. According to court documents and medical reports later cited in hearings, the violence was extreme. One victim told police Butler choked her until she lost consciousness, then allegedly did it again so he could record it on video. Another victim's physician said she was about 30 seconds from death during an attack. Several girls described being repeatedly raped or assaulted even after saying no. Initially, the Payne County District Attorney's Office charged Butler as an adult, a move victims and their families supported, believing it was the only way to reflect the severity of the crimes. But months later, that changed. In October of 2025, the case was reclassified under Oklahoma's Youthful Offender Act, a law that lets courts handle 15 to 17-year-olds in a hybrid system that prioritizes rehabilitation over punishment. Butler pleaded no contest to all 11 counts. Judge Susan Worthington accepted the plea and imposed a 10-year sentence, fully suspended, meaning he would serve no prison time as long as he completed counseling, curfew checks, and community supervision through the Office of Juvenile Affairs until his 19th birthday, which isn't that far away, guys. For families of the victims, that decision was devastating. They said the sentence minimized the violence, ignored medical testimony, and left them fearing that their daughters' suffering have been dismissed as youthful error. Fueling further anger was the perception of influence. Butler's father, Mack Butler, had previously served as director of football operations at Oklahoma State University, one of Stillwater's most powerful institutions. While there's no evidence of direct interference, residents began questioning whether social and institutional connections shaped the tone of the case. Now, the Youthful Offender Act was created to rehabilitate teenagers capable of change, not to absolve those whose actions nearly killed someone. It's meant to distinguish impulsive youth behavior from deliberate brutality. When applied to strangulation and rape, that distinction begins to crumble. So, Russ, at what point does the opportunity for rehabilitation end and the obligation to protect the public begin, and when the offender age collides with the brutality of the crime?
So clearly, with him, there was this, ongoing pattern of, whatever you want to call it, date rape, etc. Because, this was girlfriend one and girlfriend two. And so that pattern there in and of itself is really super troubling, because the reason that we look at patterns is because patterns repeat themselves. And so in this case, the fact that they were just going to let him off at 19, that kind of really doesn't bode well, I don't think, for the system. And I don't understand. I mean, maybe they were precluded by law from pushing beyond that as a range for looking at him under supervision. But to me, it seems like they should have, been working to extend that at least, in the absence of whatever their other, alleged options were. And I think that they could have picked better options overall, because it seemed to me like they were going with the most expedient route, the thing that's the easiest to do, the low hanging fruit, the least effort for the medium amount of reward, if you will. So I would say that that's what's truly disturbing about it. It's just like people they didn't want to get in there and do the hard work. And so they just wanted to go for whatever the easiest thing to do was. And it seems to me that you can prove that, because the easiest things that happened, were the things that they eventually, ended up, tasking him with, as far as his sentence went and as far as his supervision went.
Yeah. And by the way, he was, what was it, 7? I forget, but he was between, I think he was 17. I forget. He's right at the edge of turning 18. And guys, strangulation is a act of violence. It's about control. it's literally the ultimate predator. I mean, that's you breathe or not breathe. That depends on how much I control, and that usually escalates because there's a thrill behind that. There's excitement behind that. There's an arousal behind that. So that's something that needs to be checked immediately. For someone who's doing this at a young age, it's only going to get worse. It's going to escalate until we have victims that don't recover, and it's going to be a pattern, like Russ said, because this is how they get their kicks. This is how they find enjoyment, with the power and the control. I mean, again, with the Kata Scott case with Keon King, I actually thought she would have been strangled because the guy had a history of strangulation. It turned out she was shot up close. That did shock me. But maybe it's because he couldn't control her enough to strangle her. I'm just wondering if he did try to strangle her. But usually strangulation, it's a thrill. People that are prone to doing that keep on doing that because eventually they're going to get their off. And as I said, it just escalates. It's troubling to know that the people that are in a position to see these concerns and act in a way that prevent don't, and they overlook it. Because in the end, if this person winds up committing another crime and winds up killing someone, most likely maybe with the same motive, with the same cause or manner, however that would be worded. My mind's going blank there. Was it the manner of death? Is that what it is?
Yeah.
Russ, manner? I'm thinking manner of death. Anyway, using the same technique. Manner of death. Using the same technique, guys, it's only going to get worse. I think the people that are in these positions to pass, to judge, like those that are in those positions, they should be well aware of red flag behaviors. So they know exactly what they're doing, not just in the moment, but how that's going to have a ripple effect. Because if you have these things that everybody in the public knows, hey guys, this is just a spark. You can't let this go into a flame. But at the end, if people don't know that or are in positions to judge, I think we're going to wind up having a lot more lenient sentences in the near future. I don't know if you would agree with that, Russ. Do you agree?
There's, especially when you look at, with regards to his thing, there was a lot of indicators that what he was doing was not what we would call necessarily a crime of passion. It was a crime that was premeditated. There was indication that he recorded himself with regards to strangling the victim that's listed on there as KS. So if you're going that far that you're setting that up and you're going to keep that as part of a trophy, which is what the verbiage that the FBI actually uses, that's an indicator of premeditation. So this was not something that got out of hand. It wasn't an argument. This was something that he wanted to do, and he did. And so I think that that's probably the most troubling thing. I was trying to look at some of the things regarding what the youthful offender modality looks like there in that particular county. And unfortunately, it's left up to the DA. These people that are involved in sexual crimes are only technically eligible for it, and so they just went ahead and they just seems like they just bulldozed through all of this. And so all of these things, the recording of the act suggests it was planned, shows deliberate intent to capture the violence, contradicts the claim of a youthful mistake, demonstrates calculated behavior, raises questions about why he recorded it. It could very well have been that this was going to be a trophy for him. And then, it just shows that there's, for lack of a better term, there's sophistication with regards to the way that he's going about that. And I don't mean that, that he's, super smart or super brilliant, but he is engaging in a pattern and carrying it out. And that's what I mean, only by sophistication.
Yeah. And guys, I don't think justice is built on, I don't think justice is really built on prevention. I think it's built more on deterrence at some level, because you find that, you don't really do much for people that try to kill somebody. It's only after they're killed that you may look at things at a more harsher way. So with that said, it's sad because there are efforts to go ahead and we could prevent, but then people will say, well, they didn't try to, I'm sorry, you don't know if they wanted to kill them. Well, they were strangling. I mean, what else would be the motive? Well, his intent wasn't to kill her. His intent was for her to just pass out. How do you know that? Why don't we treat it as if his intent was to kill her? Because to me, that's what his intent was. Why else would you strangle somebody? But the system isn't built, sadly, on prevention. And I think that's something that needs to be looked at from the side of justice. Is at the end of the day is what are we doing long term to make sure that this person doesn't do it again? And that goes outside of just dealing with them in the moment. It goes into it goes into areas that say, hey, what's the likelihood that this person is gonna cross that line, is gonna be a threat to the next person? So I think that's something that should be revisited, because in the end, it's like, okay, well, he didn't kill her, so we can go for these charges, but he could have. He could have. And in her mind, or in their victim's mind, they thought they were dead. So it's crazy how, they don't die, but that still doesn't originally change the intent. I mean, sometimes we may have to try some energy at really trying to focus on that intent a little more and really dig deep in cases like this where, for Jesse Mack Butler, he was young, but you're strangling somebody. Let's figure out, what was your intent? Was your intent for her to pass out? Was your intent to kill her? And I think that may be worth going the distance in, because that's where you can change a charge into an attempted murder, which I think would be a lot difficult to put into a youthful offender. I think that the fact that we don't go after intent as much, because I know it's harder to prove, but the fact that we don't go out for intent is because that's where the leniency is. I mean, I could imagine if this ever went to trial, a defense lawyer saying, well, he didn't want to, he wasn't trying to kill her. He was only trying to make sure he could, that she passes out. So the laws that make leniency possible, and a bit controversial, but the Payne County controversy can't be understood without looking at the laws that made these outcomes possible. So we have the Oklahoma Youthful Offender Act, which Russ touched on briefly. That's Title 10A, subsection 2-5205, which gives judges discretion to classify 15 to 17-year-olds as youthful offenders instead of adults. The goal: offer structure, counseling, and supervision until age 19, after which, if the youth completes the plan successfully, their adult sentence can be suspended or reduced. The law does not prohibit its use for violent crimes, leaving it entirely up to prosecutors and judges to decide. Similarly, Swaim's earlier charge, using technology to solicit a minor, which is another charge that shows patterns of behavior that Russ talked about, that if you really hold them accountable seriously for those patterns of behavior, you could prevent what would be a possible rape if they go from trying to reach out with the person through Snapchat to eventually meeting them in person. So these are patterns that we need to identify. And like Russ said before, when you identify these patterns, you can kind of predict where they're going to go. And it's funny because now we have to spend more time trying to showcase that, well, this person was only doing that. He wasn't going to go out and meet with her. It doesn't matter. Why are you Snapchatting with a 13-year-old girl anyway? So at the end of the day, I'm going to look at it at the highest level. What's the possibility? Because if we don't, then you can go out and one day be successful. So the using technology to solicit a minor falls outside Oklahoma's 85% law, which mandates that certain violent offenders serve 85% of their sentence before parole eligibility. Because his crime wasn't legally categorized as violent, he qualified for suspended sentencing and early release. These legal structures were built for flexibility, but in Payne County, they've repeatedly produced leniency in cases involving sexual predation and physical violence. So the problem isn't that laws exist. The problem isn't that the law exists. It's how often local culture defaults to their most forgiving interpretation, even when the risk is obvious. So, Russ, if the law gives judges and prosecutors wide discretion, should there also be automatic state-level review when that discretion repeatedly results in outcomes that compromise public safety?
I don't think that you get away from it just by introducing a brand new layer. I think I think that if you're going to do that in regards to these sexual crimes, there has to be, a stop measure with regards to that. And one of the things that they're supposed to take into account is whether or not the victim, agrees with that or not. In this case, the victims did not agree with it, and they went ahead and did it anyway. So you can keep piling on layer after layer after layer of all of this stuff, but it's apparently doing no good whatsoever. There's already all of these reviews and so forth. So I think that it's a matter of you have to be careful with who you vote in, especially if your DAs are elected, and you have to hold them accountable. They have to be telling you what it is that they are going to do and why they're going to do it. And I just don't think that there's any follow through. I think that people have long been accustomed towards leaving it in the hands of the experts. And now we've got people that really maybe aren't actually experts anymore.
Russ, you're spot on. You know what's funny? I've learned as we're covering these cases, people are not really too concerned with the why. And I'm not talking about us outside. Of course, we want why. We want closure. Victims want why. They want closure. Victims' families want why. They want closure. But when it comes to the court system, sometimes they believe it's harder to prove the why. So to them, it's just a matter of proving the facts that they can solidify, basically what was done and how it was done. And sometimes the why gets pushed aside. I think the why is where the preventive measures are. So when you have a case like this, someone reaching out to a minor, we should be asking why. 100% we should be asking why. And that should be part of the judgment. Like somewhere along the line, we need to ask the why, so we know what's really going on behind what you're doing. Because again, you're texting a 13-year-old child. I'll guarantee you this isn't going to be the first and last time, because one, you probably have a motive behind it, right? You want to meet that 13-year-old child. You want to hook up, so you haven't done what you wanted to do. And then now when you get out, you're just going to change your plan a little bit. Maybe I'm not going to be foolish enough to put my business on Snapchat and try to do it in a way where I can groom. It takes too long. Now I'm just going to rape. That's what I'm going to do, because I got caught last time. I can't use digital stuff this time, so I'm just going to alter my route. So what you tend to do now is you wind up innovating a better predator, because in the meantime we cut off this route, then they develop another route. The first time he's grooming, and then the next time he's outright grabbing somebody and trying to potentially rape them. Screw communication, screw grooming, screw trying to get to know them. I'm just going to go ahead and do this route because I can no longer go on social media. So you go from somebody who may have been a little bit more strategic, which in that effort you can discover patterns and get to them, to someone who's more impulsive, who's a bit more unpredictable. It's just a shift in the behavior that we create, because in the end, we were lenient with the justice that should have came. Now, I got the community fallout and political heat. Both the Swaim and Butler outcomes sparked outrage far beyond Stillwater. Parents, victims, and advocacy groups flooded social media with open letters and petitions demanding accountability. I see a lot of this guy. State Representative J.J. Humphreys, a Republican from Lane, Oklahoma, publicly called the Butler outcome a complete miscarriage of justice and began pushing for a grand jury investigation into Payne County's judicial and prosecutorial practices. Humphrey proposed reviews seek to examine potential patterns of leniency and whether relationships between local judges, defense attorneys, and OSU, that's Oklahoma State University affiliated families, have influenced outcomes. He mentions that Judge Susan Worthington, who presided over Butler's sentences, had become the focal point of criticism. This isn't her first high-profile leniency controversy. She previously faced scrutiny for granting bail in a murder case and for similar youthful offenders designation in violent cases. For many in Payne County, the issue is no longer just these two defendants. It's whether the courthouse has drifted too far from the community it's supposed to protect. So, Russ, when public outrage over sentencing reaches this level, should it be viewed as mob emotion or as a legitimate signal that a community has lost faith in its justice system and demands reform.
I mean, that's all of it. It's just that, community members really need to be, more ingrained in the things that are going on in their community. They need to be going to, town halls. They need to be speaking up. They need to be asking questions. And when those questions get answered, or when they don't get answered, that gives you a lead and an insight to where things are, and then you can focus on them. But once again, I think that we've just fallen too far away from being involved, because we've just assumed that there's other people that know best, and we've let them take the reins. And now we see just how badly some of them have come to fail us.
Yeah, and Russ, I gotta ask you one question, just to go back a little bit with corrections. Russ, how much have we learned in corrections when you're lenient on one side and you have people that this is just their behavior, then they wind up finding other routes that are harder to get them out? Right? Would you agree?
That's definitely true. There's whatever you want to call it, counter forensics, if you will. There's things that I've caught inmates doing where they're seeking to counter their culpability. They're seeking to counter being found technically in possession of dope or whatever it is, and that's just part of the way things go. I think that what we're talking about here is they've come to an expectation, these predators have, that no one is going to stop them, though. And all of these other things that these guys were involved in, one of them had 10 or 12 different violations. It was hard to tell exactly when all of those occurred, but I was just wondering, why is the probation or parole department allowing that to happen with someone who is a proven predator? That the idea that someone that's a proven predator is going to be allowed to do that is ridiculous.
All right, Russ, I got one more section and then closing. What these two cases say together, side by side, Swaim and Butler tell a story that's disturbingly consistent. Swaim groomed a 13-year-old, received a suspended sentence, reoffended 6 years later, finally sent to prison only after multiple new allegations. Butler violently assaulted multiple girls, reclassified as a youthful offender, remains free under supervision with no prison time if compliant. Both outcomes were legal, both relied on discretionary leniency, and both reflect a justice system that seems to prioritize second chances for offenders over safety for victims. Patterns matter, like Russ said. When lenient sentences for sex and violence repeat under the same jurisdiction, it's no longer coincidence, it's culture. Russ, this is the last, one more question after this, then it's done. When the same county repeatedly extends leniency in sexual and violent cases, does that point to individual misjudgment or to a judicial culture that has forgotten who justice is meant to protect? And I know that's a question that resonates with you because you are very big on justice. And, what's your thoughts when
I think the bigger question is whether or not there's corruption involved. And so, corruption can be everything from, undue influence to taking bribes, or to just, being willing to do whatever it takes to meet a certain other agenda. And so that's what, so there's always the potential for different types of corruption. And so I think that, corruption can even be, just not being very good at your job, just, not being willing to be held accountable. And that's what you've seen through both of these cases repeatedly, is there's just a complete lack of accountability. And they took the power away from the victims first, and then they took it away from the public. And now they're in the business of, just trying to go ahead and get away with it and sweep it under the rug. So that's kind of where it is.
Yeah, and guys, we saw it also in Kohlberger's case in Idaho. Steve Goncalves or Goncalves. I'm not good with names, guys. Bear with me. But I watched an interview he did on News Nation, and he was very upset that they weren't involved in, this plea deal that they didn't know. They thought it was going to be a joke. And then eventually turns out Brian Kohlberger got to make a plea, and there was no death sentence, no death penalty. And they were very upset with that, because who was listening to the victims or the victims' families in that case? And I think we see more of that. Russ mentioned that earlier as well, that, you want justice. Justice really comes from the people that were affected by it. The conversation should start from what's in their best interest. Closing reflection. So as of now, Seth Swaim is finally serving 8 years in the Oklahoma Department of Corrections, but only after years of warning and preventable harm. Jesse Mack Butler remains under youthful offender supervision until at least December 8th of 2025, when the court will decide whether he successfully completed his program. If he has, his adult record will remain suspended and he will walk free. For victims and their families, I lost Russ for a second. There he goes. For victims and their families, let me get Russ back in. For victims and their families, that contrast feels unbearable. One man repeatedly manipulated minors until a system caught up years later. Another nearly killed his victims and avoided adult prison altogether. Both outcomes are the result of judicial discretion, and that discretion now defines Payne County's justice reputation. So, Russ, and you can go right into closing with this, Russ. How do we rebuild public faith in a justice system that claims to protect the vulnerable when its most lenient decisions seem to keep putting those same people in harm's way?
Ultimately, it has to be community-based, and people have to be, willing to, get in there, ask those questions, and provide oversight. And I don't mean in a formal way, but with being active in the community, being active in ways where they can go in there and question what the DA is doing, question what the sheriff is doing, question what your local jail is doing, question what your local probation department is doing, question what your state parole board is doing. Here in California, we have a horrible parole board. They just let everybody off. Oh, you were involved with Manson? Yeah, you get parole. You get parole. Everybody gets parole. So it's, and only when the case is like something that's, recently heinous, do they even bother to try and pretend that they're being hard on crime anymore. Don't let it become that way in other places. California is a lost cause now. Some states aren't.
Yeah, and guys, listen, the reason why we do these true crime talks is to support the victims. I think sometimes victims get hurt when there's more people behind them. I think that's the good thing about channels like this and other true crime channels, and even the news sometimes, is that they get behind the victim. I just wish people would stay with the message and don't shift like I see in the Celeste Rivas Hernandez case. I just stay with the victim. Stay with the victim, because they need a voice, because all this shit comes out after the victim's been removed from the equation, so the victim can't speak, which gets me upset. And I know November 4th is P. Diddy's birthday. Russ may want to give a shout out to that.
Oil.
As always, guys, the show is tiered up. If you haven't, be safe. And guys, if you have cases that you want us to cover, please email us. I'm going to work on a case that was sent my way. I haven't forgot about you. It's in my email. I'm going to send it over to Russ soon, and we'll kind of give a deep dive. That case is a little bit old. It's about 4 years old, so it's really no updated information. So me and Russ have to take our time and try to find angles that we feel can create the biggest impact. But email us, GangiAnthony@yahoo.com, GANGI Anthony@yahoo.com, or Russ's email. Russ, what's your email?
Sierra.sargent@gmail.com.
And the spelling of that?
SIERRA dot, and then Sargent is the common spelling, which is tricky, but it's SERGEANT@gmail.com.
Yeah, I wasn't asking about Sierra. It's a damn sorry. I can't even spell it. I was a sergeant for a few years. As always, guys, the show is Tear Talk. Stay safe.